Well, good evening. A very warm welcome to all of you. Today, we're diving into a topic that's very close to my heart and becoming increasingly significant, and the growing popularity of arbitration for competition disputes. And with the rising number of arbitrations where competitions are at play, we will be focusing on three areas in the seminar, well, at least in the first part of the seminar. How private enforcement of competition claims has developed in the US, EU, and the UK, the types of issues that can arise in competition arbitrations, and what Hong Kong can learn from the international experiences to stay at the forefront of this evolving landscape. The moderator is unfortunately underwhelming, but we have an overwhelmingly impressive panel of speakers lined up today. First, Brent Snyder, sitting in the middle there, needs no introduction. He is a rock star in the nerdy world of competition law. As the former CEO of the Hong Kong Competition Commission and former Deputy Attorney General at the US DOJ's Antitrust Division, he has second to none experience in prosecuting cartels. Now, after many years of hunting down cartelists, he has finally decided to switch sides and is currently a partner at Wilson Sonsini's San Francisco office. Next, we have Jindrich Kloub, another familiar name. He has been referred to as the Ryan Gosling of Hong Kong. And even inspired a TV character based on his time as the executive director of operations at the Competition Commission, where he led many high-profile precedent-setting investigations in Hong Kong. And as if that's not enough, before that, he tackled many groundbreaking international cartels at the European Commission's DG Comp. He's now based in Brussels, heading Wilson Sonsini's European antitrust team. Joining us from the London office of Wilson Sonsini is Kassie, who specializes in investigations and regulatory compliance. He will provide us with an update on recent developments in the world of sanctions, export controls, and foreign direct investments in the final part of this seminar. We're also very pleased to have Kassie Smith KC joining us remotely from London. Kassie is a leading specialist in competition litigation at Monckton Chambers. She recently led the team representing the Commission in the landmark Linda case, the first enforcement action ever brought in Hong Kong involving an abuse of substantial market power. Anneli Howard KC is another top-tier competition soap from Monckton Chambers. We're very fortunate to have her here today because she just arrived in Hong Kong last Friday. She's here to represent the Commission in the first resale price maintenance case, which trial is taking place next Monday, I believe. Anneli, you're very lucky to have avoided 2 typhoons. But thank you very much for bringing the British weather with you. Last but not the least, we extend our gratitude to Louise Wong for joining us. Louise is over there, wave. She's a special counsel at HKIAC and the Secretary General of the Asian Domain Name Disputes Resolution Centre. Now, before I dive in, I'm very excited to introduce to you Zoltán Barakonyi, who is joining us remotely from Budapest today. Zoltán leads the antitrust practice at Baker McKenzie's Hungary office and is the newly elected president of the LIDC, International League of Competition Law. Zoltán and I have just returned from a highly successful LIDC Congress in London. He will provide us with a brief introduction of the work of the LIDC and hopefully inspire all of you to get involved and join the Hong Kong chapter of the LIDC. So Zoltán, the floor is all yours.
Thank you very much, Catrina, and good evening to everyone. Thank you for the introduction. Well, on behalf of the League of International Competition Law and the Bureau, I would like to thank the invitation. I'm very happy to attend this conference remote because, as I was introduced, I am a competition lawyer. Also, I am a litigator. I am basically in disputes, both in administrative and civil cases and in arbitration. So that's a very, very, very exciting topic for me as well. But first of all, I would like to emphasize how very happy we are at LIDC that we have this local group, this chapter in Hong Kong, which I think was a major step towards our expansion into the Asia-Pacific region. And special thanks to Catrina, who is a real engine, I think, in LIDC, who was just elected as the first vice president now of LIDC. And she was working very hard on basically acquiring new members. And I'm very happy to tell you that the latest local group is the Austria-New Zealand chapter of LIDC. So I think in Asia and the Pacific region, very important for us. So just a very, very brief introduction to the International League of Competition Law. This is a Swiss-based professional organization which was formed in 1930. Probably you know a lot about competition law history, so you might know that there was a World Economic Forum of the League of Nations in 1927, which gave a push to the development of competition laws in Europe. And therefore, it's no surprise, you know, that at that time, mainly IP lawyers and lawyers who were working on the unfair competition area formed this organization. And after almost 100 years, this organization kept this unique, I would say, combo of practices, which is, I think, makes it very exciting, especially today's world, where IP, unfair competition, and antitrust lawyers are working together. What are we doing? Of course, we have a scientific committee, which is always discussing what are the most important and relevant topics, you know, to discuss and work on. We have working groups, just to pick two of them, the digital regulation group or the distribution franchise e-commerce. You can imagine that, again, areas where IP law and competition law really meet. But the most important event every year, as Catrina already mentioned, the Congress, where we are basically discussing those two topics, one in antitrust and one in IP, unfair competition, where on which the national groups are working basically for almost a year. And these reports are then combined into an international report discussed, you know, at these congresses, and then published every year by Springer. So it's really, I would say, a very scientific, but at the same time, very relevant practical work I think we are doing. In London, for example, one topic was private enforcement. We just had, you know, the 10th anniversary of the directive. So it was, I think, very important to see, not just in Europe, but worldwide, you know, where we stand now. And the other topic was the copycat packaging, which is also, of course, very important, relevant. Next year, we will meet in Vienna. The Vienna Congress will be on the 10th and 11th of October. So if some of you would like to take part in an interesting professional event and maybe combine it with a pleasant European vacation in Vienna, Budapest, Prague, it's still not too late to contact Catrina and sign up. The topics will be this year, again, I think for me, very exciting and very relevant. The relative market power, relative dominance, which is very, I think, important in different countries, and very important that it will be a very interesting comparative study, because there are very, I would say, diverse rules in this regard in various jurisdictions. And the other one, in the IP unfair competition area, is the digital platforms and what kind of prohibitions, what kind of obligations should be applied in connection with infringements, especially on IP and unfair competition. That's very interesting because we had a similar topic like 10 years ago. So it will take it will give us the opportunity to compare where we are, you know, in 10 years time. So I think I don't want to take too much time. Maybe that introduction gave you a little bit of taste of what we are doing in the International League of Competition Law. And once again, I'm very happy that now we are in Hong Kong. And I hope that we will meet many of you in Vienna next year. Thank you, Catrina, and thank you for having me.
Thank you, Zoltán. So if any of you want to get involved in LIDC Hong Kong, please do drop me an email. And with that, I think we'll begin our first segment, which is about how private enforcement in competition claims has developed internationally and whether it is time for Hong Kong to follow suit. So, Brent, the US has had a very long history in the private enforcement of competition claims. Can you tell us how that has developed over the years and why it is important to have private enforcement available?
Sure. So for those who aren't familiar, the United States has had an antitrust or a competition law since the late 1890s. The US and Canada were the first jurisdictions to have these laws, and private enforcement has been a critical component of the US system almost since the very beginning, since certainly the early 1900s. And it is standalone private enforcement, meaning that a litigant doesn't have to wait for a US antitrust enforcement agency to bring a case and win the case before they can file a case. Instead, if a party feels that they've been aggrieved or harmed by a violation of the antitrust laws, they can bring their own enforcement action to recover damages for the harm that they've suffered. And as we'll touch on probably during the course of this, we have a class action system in the US as well. So you can sue based on the harm to you. But if you think that your harm is representative of a harm that has been inflicted on many others, you can also be a representative of a class of plaintiffs, a class of individuals who are seeking recovery under the antitrust laws. Now, I was in enforcement at the US Department of Justice for quite a number of years, and I could appreciate why we had a private system in the United States. The key thing is that it increases enforcement. It's what I would call a force multiplier. The private enforcement is intended to fill the gaps that public enforcement doesn't get to. The United States has two enforcement agencies, the US Department of Justice Antitrust Division and the US Federal Trade Commission. They can't possibly, even with the resources that they have, come close to addressing all of the competition issues that arise in a country as large as the US. Certainly, Hong Kong, with a relatively new commission and small commission, also can't possibly reach all of the competition issues that may arise in a city like Hong Kong. So that is, in my opinion, the key reason why private enforcement is important. I think I read statistics that the ratio of private cases to public cases is more than 10-1. So for every public case, every case that I could bring when I was in enforcement at the antitrust division, there would be probably at least 10 private cases in different forms that would be brought. And frankly, I was surprised the ratio was even that close. I would have thought it was far more than 10-1. So that's one of the key reasons. Another key reason that's related to this is you don't want victims of antitrust conduct to have to wait on government enforcement. That enforcement may never come. It may not be detected. It may not be enforced. Enforcement agencies at every level, whether you're talking the United States or Hong Kong, they have to have priorities. They can't pursue every single case that hits their radar. They simply don't have the resources. And you could have a situation, I think, where you have follow-on enforcement, where it can almost become a political decision about what cases you bring. You're deciding who you are going to enable to bring their own, follow-on litigation. We don't have to worry about that in the United States. Plaintiffs will bring cases, plaintiffs' lawyers will bring cases if they believe they have merit. Now, they will often come into the Department of Justice and pitch the Department of Justice to also pursue those cases, but they know they're not dependent on the Department of Justice to bring those cases. The other thing that two other points I would touch on just very quickly, and then I want to quickly touch on the cons of private enforcement. But one is that there's the theory that it reduces the need for government funding for antitrust enforcement, because when plaintiffs can do a fair bit of their own enforcement, you don't have to invest so many resources in government enforcement. We'll get to the con, because the criticism is that very same. One of the criticisms of private enforcement is that very same point. And then finally, it facilitates the development of the law. In the US, our antitrust framework is, the antitrust laws are general, to say the least. The first antitrust act in the United States really amounted to two different sentences, both of which were very poorly drafted. And so it's taken us really the entire existence of the antitrust laws in the US to kind of tease out through litigation what they actually mean. Well, we've been assisted in that through the private enforcement process. Not all precedent, it has to wait for the government to get around to bringing a case in an area. And so, private enforcement kind of fills that void as well in helping the law to develop. Now, as I said, it's not without its criticisms that we have private enforcement. The first is the one I already touched on. It may be an excuse to underfund public enforcement of the antitrust laws. So it's kind of two sides of the same coin. There's also some people that believe that treble damages liability. So in the antitrust laws of the US, if you are found guilty of an antitrust violation, well, I shouldn't say guilty because that's a criminal concept, which is what I used to do. But if you are found liable for an antitrust violation, a civil antitrust violation, your liability is treble damages. So if the harm from your conduct is $10 million, then the award that the plaintiffs can get is $30 million. And there is some concern that extreme liability may cause courts to be reluctant in civil cases to push out the envelope of antitrust liability. I don't personally believe that, but I know that's at least one of the criticisms that exists. I also think, and this is an important concept when it comes to Hong Kong in particular, but I felt this even in the US, is that the antitrust enforcement agencies can lose some control over the development of the law. Where, there might be a case that you would like to lay the groundwork to bring from a public enforcement standpoint, and you can have some civil plaintiff run in and file that case. And I used to think of it in the criminal context of trampling my crime scene. They can, advance the law maybe in ways that you're not ready, or you might prefer they don't advance the law until there's been public enforcement. Now, there are ways around that. The Antitrust Division and the Federal Trade Commission will often file statements of position in these civil cases where they can articulate for how they think the law should develop. But that is another area that at times is a criticism. And, I think all of these things are manageable.
Great. Let's turn to Europe. Jindrich, there has been an enormous rate of growth in competition, private enforcement of competition claims in the EU, particularly after the damages directive in the past 5 to 6 years. The values at stake are increasing significantly. And I think the trend is likely to continue with more EU member states introducing collective redress mechanisms. So can you tell us how EU has reached this very active phase and why, and how that might inform Hong Kong's development of its own competition regime?
Thank you, Katrina, and thank you for the invitation to be here with you today. Let me start more than 60 years ago, and I promise I will not exceed the 8 minutes you allocated. And the only reason to do that is because I was at a conference 2 weeks ago where Justice Godfrey Lam, who was the president of the Competition Tribunal, who decided some of the first precedential cases, made an observation that one of the surprises that he sort of sees is that there has been no follow-on, because there's only a follow-on right of action in Hong Kong. There has been no follow-on claim since the introduction of the ordinance almost 10 years ago. And, you know, there has really not been any meaningful enforcement in Europe for at least 40 years, during which it has been theoretically possible. So the basis for bringing claims in Europe is the infringement of Articles 101 or 102 of the Treaty of the European Functioning of the European Union. These articles have been there since 1959. Already in the 60s, the court has confirmed that certain articles in the treaty have something called direct horizontal effect, meaning that they produce rights and obligations between private parties. It took another 40 years before there was another judgment by the Court of Justice in the famous Courage case coming from the UK, which specifically confirmed that Article 101 has direct horizontal effect, and that its infringement can give rise to a claim of damages, and that there exists a right to be compensated fully for any damages incurred as a result of its violation. And again, it didn't really unleash the gates with follow-on claims being filed, let alone standalone claims. It took another series of judgments, you know, the Manfredi judgment and many others since then, to change the picture. But what has really changed the situation was the introduction or the adoption of the so-called European Damages Directive, which is a directive that the Commission or the European legislators adopted in 2014, but that the Commission has worked on already since 2006, having seen the judgment in Courage, having seen the judgments in Manfredi, and having looked at the US with some jealousy of the force multiplier and of the ratios. It has really thought hard about how to spur follow-on or damage actions in Europe. And I keep saying follow-on because despite there being a standalone right of action, the vast majority of claims in Europe being brought are follow-on claims. And so it is with that jealousy that it got to work on what became the Damages Directive. And that work started in 2006 with the publication of the so-called Green Paper. Then there came a White Paper, and then the work commenced on the Damages Directive. And at the time I was at the Commission, and I had the honor of working on an aspect of the directive that related to how private enforcement will interact with public enforcement. Because at the time there were concerns that private enforcement could undermine public enforcement, because it could, for example, undermine the incentives to come in for leniency, if leniency material were disclosed in the context of follow-on damages and so on, which led to the introduction of some safeguards in the Damages Directive, which, you know, I will leave aside for the purposes of today. But what has really unleashed the huge wave or avalanche of follow-on claims that we're seeing in Europe in the last 5-6 years? And the avalanche is really, it's immense. The Commission did a study and it said that in 2015, there were about 50 cases across the EU with, you know, adjudicated claims for damages. And in 2019, there were already 239. And since then, the numbers have been increasing exponentially. Only in the trucks litigation, so the Commission adopted a decision sanctioning the trucks cartel, I believe in 2016, I might be mistaken, the exact year. And in that case, the Commission imposed fines of almost 4 billion on a number of truck makers. Since then, there have been follow-on claims filed across the whole of Europe, including the UK, which is no longer, unfortunately, part of the EU. And just to give you an idea, the overall value of claims is estimated at more than 15 billion euros. So almost 4 times more than the fines imposed by the Commission. In Spain alone, the follow-on litigation has led to 1,185 appellate judgments on claims brought on the back of the truck's decision. So this is an incredibly active damage litigation landscape. So what has unleashed it? Where is the judgments or so on? Well, all of it, that led to it. But there were 3 main things that the Damages Directive addressed, obstacles that were identified as standing in the way of an effective damages actions regime. Number 1, it addressed the question of disclosure. So availability of information that plaintiffs need to bring an action in court, which in most European countries is quite difficult or was quite difficult before the Damages Directive. It created a presumption that an antitrust violation causes harm. The overcharge still has to be, proven. But some member states, and they implemented the Damages Directive, like Hungary, Zoltán would know, introduced even presumption of the amount of harm. That was another change in the Damages Directive that was important. Then it addressed the Damages Directive, not directly, but a related recommendation, the aggregation of claims, the question of aggregation of claims. And finally, it also started addressing the question of financing of damages litigation. It is the combination of these areas being addressed that I believe has led to the explosion of claims across Europe. There must be an effective way to aggregate claims, and the European Commission has done more work in that area, or the European Union recently adopted a directive on representative actions, encouraging member states to adopt representative actions. In Europe, we really don't have opt-out class actions like the ones that Brent described in the United States, but there are representative actions, opt-in actions available in some member states. So that is a critical ingredient. Another not less important critical ingredient is the financing of actions, because a class of plaintiffs is unlikely to finance the litigation for many years and bear the risk of having to also bear the costs of the other side in case the class loses, without there being an effective way of financing that action. That has led to some, I would say, excesses in Europe, where we don't have contingency fees, but instead we have a wild west of litigation funders who have really taken this as an investment. And you have, hedge funds that are going into financing litigation and so on, which has led to some blowback. And there are considerations of actually aligning the playing field across Europe. So these are some of the changes that have led us to where we are now.
Thank you, Jindrich. Now let's turn to the UK. Kassie, equally in the UK, there has been an explosion of private competition actions over the past few years. Can you tell us why have these actions become so popular in the UK, and what are some of the issues that have emerged in these proceedings?
Yes, of course, Catrina, thank you. I hope you can all hear me okay, many thousands of miles away. But in the UK, the relevant competition rules are found in sections 2 and 8 of the 1998 Competition Act, and they're known as the Chapter 1 and Chapter 2 prohibitions. They reflect almost exactly Articles 101 and 102 of the TFEU and prohibit anti-competitive agreements and abuses of dominant position. As in the EU, the prohibitions contained in the Chapter 1 and Chapter 2 prohibitions are directly applicable. So they give rise to individual rights which can be directly enforced in the UK courts. As a result, any provision in a contract that's found to be in breach of Chapter 1 prohibition is void and unenforceable, and any loss caused by anti-competitive arrangements or abusive behaviour in breach of the Chapter 1 or Chapter 2 prohibitions can be claimed in actions for damages. Unlike in the US with its system of triple damages, we're not so ambitious in the UK. We have a regime of tortious claims for standard compensatory damages. But that doesn't stop there being, as I'll explain, some eye-watering sums being claimed in the cases. So as Catrina said, there's been an explosion of private competition actions in the UK courts over the past few years. Such actions have been both follow-on actions for damages, such as those in the EU, where there's already been a decision by a regulator, a decision by the UK Competition and Markets Authority or the EU Commission. And in those cases, the regulatory decisions are relied on by claimants in order to establish the liability. Your job is already done on that part of the case. And as a claimant, you only need to establish causation and loss. But there have also been an increasing number of standalone actions for damages, such as those explained in the EUS, where the claimants argue from scratch a case on both liability and damages. Things have happened a little more quickly in the UK than they have in the EU. As I said, we introduced our modern competition law in 1998. And as I will explain, matters have accelerated significantly over the past few years since legislative changes in 2015. Why have these competition private law actions for damages become so popular in the UK? There are obviously a number of reasons, but in my view, the most important are as follows. First, like any regulator, and I note what Brett said about this as regards the states, the UK's Competition and Markets Authority, the CMA, has limited resources at its disposal to carry out competition investigations that might lead to a decision and the imposition of public law penalties. The CMA sets out its priorities each year in its annual report, and they make it clear that they can and will only focus their resources on investigating certain types of conduct in certain industries. They've also made it clear that they will look to what they call private enforcement. That's private actions in the courts to discourage anti-competitive behaviour in other markets or other areas. So an emphasis is put on private enforcement by the regulators, and that gauntlet has been taken up by the legislator in the UK and by the courts. So the second issue, I think, is that the attitude of the UK legislator and of the courts has been to facilitate and encourage private law actions for damages. Since 2003, we've had a specialist competition court in the UK, equivalent to the High Court, the Competition Appeal Tribunal. And that comprises 3 panel members, typically a High Court judge and an economist and some other commercially qualified panel member. And so that tribunal is well equipped to understand the complex issues that can arise in competition damages claims. Competition claims can also be heard and are also heard by the High Court. And in 2015, as I've mentioned, a number of reforms were made in the UK by way of the Consumer Rights Act, which were designed to make it easier for claimants to bring damages claims in the UK. In particular, the Act sought to make the Competition Appeal Tribunal the go-to forum for bringing competition damages actions in the UK. And it widened the remit of the types of cases that the CAT, as we call it, can hear. Before 2015, standalone damages could only be made in the High Court, could only be brought in the High Court. But from 2015, they could be brought in the CAT, as well as follow-on damages actions. So the number of standalone actions in the UK has grown exponentially, so that now we find that those standalone damages actions are actually the norm rather than the exception. I haven't done a tot-up of the number of cases, but I think proportionately there are probably a much larger number of standalone actions for damages in the courts and the CAT than follow-on actions in the UK. And that leads me to my third key point, which is that the English system generally has always been very well equipped for claimants to bring competition law actions. In particular, I emphasise our well-developed and extensive process for disclosure of documents. And that disclosure process, the powers that the English courts have to order disclosure, is incredibly important in competition claims. It's essential to enable claimants to prove liability and damages in competition claims, where generally conduct is hidden, the effects of that conduct are hidden, and difficult to prove without access to internal business documents. So if you're able as a claimant to gain access to these sorts of documents through disclosure, That makes your life a lot easier to prove a competition damages claim. And in 2015, the CAT already had a broad power to give directions for disclosure, but it also now has the power since 2015 to order third-party disclosure where documents are likely to support the case of the applicant or adversely affect the case of another party. So the CAT has extensive case management powers that has enabled it to develop massively the workload and the number of cases that it hears. And then fourth key issue, I think, is in 2015, we introduced a new regime for class actions in competition cases in the UK. In the CAT, class actions can only be brought in the Competition Appeal Tribunal in the UK. But that new regime permits opt-in but also opt-out collective proceedings and allows any nominated representative approved by the CAT to bring a claim on behalf of a defined group of claimants who then share the award of compensation. And after an initially slow start, the class actions have taken off big time in the UK. The Supreme Court handed down judgment in the Merrick's proceedings, which was a class action claiming damages for multilateral interchange fees against Visa and MasterCard. And the Supreme Court judgment in the Merrick's proceedings basically set the scene for class actions in the UK, and the court made it clear that the threshold for certification of class actions was low. So class actions have to be certified before they can proceed by the CAT. But there's a low threshold for certification. All that's required for a class action to be certified is that it's first arguable and two, triable. Arguability is that the CAT has applied the normal threshold for arguability that would be applied in any strikeout case. There's no higher, the Supreme Court rejected the argument that there was any higher or elevated merits threshold in a class action. So unless a case is clearly unarguable, it won't be struck out at the certification stage. And as for triability, in order to persuade the tribunal to order a collective proceedings order to certify a claim, the class rep must put forward a methodology setting out how the issues that they've identified will be determined at trial. That's typically set out up front in an expert report. So we get an expert's involvement at a very early stage in these proceedings. And all that the expert methodology has to show at this stage of certification is that there's a realistic prospect of establishing loss on the facts of the particular case in question. It has to provide a blueprint of the way ahead to trial. And we've seen the CAT applying a very constructive approach to certification and to the methodology. And even when it has held that the methodology is not good enough, that a class rep has put forward, it's given that class rep another go, as it were. It's given the class rep a second opportunity to come back, fix any problems with their methodology. And a number of claims in the UK have been certified on their second try. So the CAT is taking a very constructive approach to certifying class actions. So as a result, the number of opt-out class actions in the UK and the reach of scope of those actions, as I said, has exploded. As of today, there are about 20 such claims that have been certified by the CAT and which are live. And there are about 25 claims which have been issued and are awaiting certification, as well as other claims that we know about that are in the pipeline. So those claims are massively diverse in subject matter based on the Chapter 1 prohibition and classic cartels, but also increasingly a number on the Chapter 2 of prohibition and abuse of dominance, particularly in digital tech sector. They're generally made on behalf of classes numbering millions often consumers, and for often eye-watering sums of money. So just to give you a couple of examples of the diversity of some of the class actions we're seeing in the UK, recently new collective proceeding order claims have been filed against Atlantic salmon producers on the back of a investigation into a cartel between those producers by the European Commission, alleging that they engaged in unlawful collusion to increase salmon prices. And the claim is brought on behalf of, I think, 35 to 44 million UK consumers who bought salmon during the relevant period. Interestingly, the opt-out class proceedings are being brought alongside individual proceedings by a number of supermarkets against the salmon producers. But I'll come back to how very briefly to deal with how the courts have dealt with those cases where a number of claims are brought alleging similar infringements. And just to give you another example at the other end of the spectrum, to illustrate the diverse nature of class actions, case in which I'm currently instructed is an opt-out collective claim being brought by a class rep, Mrs. Cole, against Google for alleged abuse of dominance relating to Google's practices in its Play Store. That's including the allegation of charging an unlawfully high commission rate to developers of 30% on charges for certain app and in-app purchases. And that claim seeks estimated damages of up to £920 million on behalf of about 19.5 million UK users of the Play Store since October 2015. And again, that class action will be heard alongside an individual action based on essentially the same allegations brought by Epic Games. You may know them as the developer of Fortnite. They're also suing Google as regards the commission and its practices on its Play Store. So the explosion of these opt-out class actions in the UK CAT has been made possible in the UK by the development of litigation funding arrangements, a market which has also rapidly developed recently in the UK. Now, in July 2023, the Supreme Court held in its judgment in PACCAR that litigation funding arrangements based on funders receiving payments based on the amount of damages recovered are damages-based agreements and unlawful. But that hasn't stopped the funders, who are, if nothing, imaginative. They've amended their funding arrangements so as to essentially include payment based on multiples of costs incurred over time. And it's certainly not put a brake on the number of CPO claims being lodged with the CAT. So in conclusion, all of those factors, and I highlight particularly the development of the opt-out collective proceedings regime, the low threshold for certification, and the availability of litigation funding, have provided powerful conditions for private enforcement in the UK. As I said, though, the private enforcement is not limited to collective proceedings. There are a healthy number of private actions brought by individual claimants. Those are usually larger businesses that can afford to bring actions on their own account. And as I've also said, those actions often raise similar issues to those in the class actions. I've given the example of the Google Play Store case and the salmon producers case. And that has meant the CAT has had, in particular, Competition Appeal Tribunal in particular, has had to engage in some very imaginative and hands-on case management approaches in order to deal with those sort of cases, including, and I could do another session on how it's done that, but some issues of full and partial joint case management, ordering single consolidated pleadings on the parts of common defendants, and joint expert evidence. So the CAT has had to run to keep up with how things are developing in the UK, but it's done so far a relatively decent job. So as to how those proceedings have unfolded, we've seen, as I said, many cases being brought. Not many have yet made their way through to a publicly litigated conclusion, although there have been some settlements. There haven't been any final judgments yet in opt-out class actions awarding damages, but a number of substantive trials on liability and quantum were heard, have been heard this year, particularly Le Paterel and the Boundary Fairs proceedings, and we should be getting judgment in a number of those cases in the next few weeks. That's going to how the judgments come out, how the damages awards come out, and in particular how the funding awards are made by the court will obviously affect how the market develops in the UK in the future. So it's interesting to see, keep an eye on those judgments that are coming out shortly.
Thank you, Kassie. I understand that there's another factor that's expanding the scope of collective actions in the UK, which is that parties are increasingly advancing more novel forms of abuse. Anneli, can you tell us a bit about that?
Yes, just very quickly, because I remember 10 years ago acting for a regulator who had to justify why they were introducing price cap. And part of their reasoning was because the prospect of somebody bringing an excessive pricing claim was just far too difficult, impossible, that they would never get it off the ground. And you look back now over 10 years to see this plethora of abuse cases before the CAT, where actually excessive pricing is now regarded as pretty plain vanilla and the easiest form of abuse case to bring. That's not to say it is easy, because obviously it's incredibly difficult to bring on a standalone basis. But has been an explosion in other novel forms of abuse, focusing not just on exclusionary abuse, but a lot of different forms of exploitative abuse. And I think everyone's attention's been absorbed on forms of exclusionary abuse because of the Commission's guidelines. There are no equivalent Commission guidelines for exploitative abuse, and this is really being developed and explored through the courts in litigation. I think, like, to echo what Kassie said, there are three main factors that are driving this. One is the availability of funding, which basically takes the cost risk out of the equation, takes it off the company's balance books for bringing the claim, and absorbs some of the risk. Secondly, it's that disclosure and the innovative ways that lawyers and the CAT are using to minimise the disclosure burden, and the creativity of the lawyers and the economists, again supported by the reinforcement of the funding arrangements. And so what parties are doing, and I think probably Brexit's helped as well, because we're not channeled into this particular route of just looking at the Commission decisions. We're adopting a really international approach and sort of a horizon scanning across different jurisdictions, looking at what's going on in the US, what's going on in Korea, what's going on in Australia, what's going on across Europe, not just in the competition field, but of course in related fields. So we're seeing claims for abuse now that are based very much on consumer-driven practices, which obviously there's a parallel aim with competition law, protecting consumer welfare, which folds into exploitative abuse. And so two of the cases that Kassie mentioned, that the Gutman boundary fares, there's also another trains fare case, and there's an Apple iPhones case, which are all framed in terms of lack of transparency and lack of fairness, that a company that's got in a dominant position has somehow hoodwinked consumers or distorted their choice and the factors that go into making their purchasing decision, and have abused their position in inducing them to make a choice, a purchasing decision that they wouldn't have done otherwise. Other examples, Kassie mentioned that Le Paterel, again, that's a regulatory decision taken by Ofcom in a markets investigation under the telecoms regime, but it's been repackaged into an excessive pricing claim, saying, well, actually, Ofcom found that the prices for fixed telecoms were excessive and above what it considered to be the fair competitive price. And it's relying on that decision to then form the basis of the case of abuse, to bring the abuse action. And we've got other examples where people are relying on maybe competition authorities' decisions from South Korea or from the US, or settlement decisions, proceedings in the US, to then rely on abuse like the Qualcomm litigation, excessive royalties, again, relying on decisions across different jurisdictions. And these kind of parallel proceedings that are being reinvented are a really useful way of breaking that disclosure problem, because you always think, hang on, how am I going to, the costs, economic costs of establishing not just the relevant market, but dominance, and then the abuse are just so high, that's a real deterrence to bring a claim. But the CAT is often very pragmatic, and it has active case management. So it says, right, what we'll do is we'll run this case as on a split trial. We'll just look at liability, so you don't have to spend loads of money on quantum. We'll take a dominance as an assumption. So that cuts out a whole burden of the economics of proving the relevant markets and dominance. We'll just look at abuse. And lo and behold, there's a ready baked pack of materials from this regulatory investigation in another jurisdiction that are in the hands of the defendant. We can just get that ready baked pack, bring it across, and we've got a whole base for disclosure to proceed with the abuse. So there are other inventive mechanisms that are being used, like settlement decisions. Kassie mentioned the trucks litigation. If somebody's made an undertaking or commitment or a settlement in front of a regulator in another jurisdiction, then the Court of Appeal jurisprudence in the UK has said it's an abuse process for that defendant to then go back on those concessions and admissions and deny them, or to advance contradictory evidence in damages actions. So you can't force the claimant to relitigate from scratch. So we're really seeing there's a combination of different tools that are being really used to expand the horizon of abuse and enable these claims to be brought.
Thank you, Anneli. Just very quickly, before we move on to arbitration, Brent, do you think it is time for Hong Kong to allow private standalone competition actions?
Yes, really for all, it wouldn't have necessarily been my answer a few years ago. But now, yes, for all the reasons that I think the US system has them, but primarily so that victims aren't dependent on public action to be able to recover for harm to them. A decade ago, when the commission was just, when the law was just coming into effect, I would have felt differently about that, because I would have been concerned that some of the foundational precedents could have been set without the input of the HKCC. But thanks to the work of Catrina, Kassie, Anneli, starting next week, and others who have come out and tried some of the key first cases, a lot of those foundational precedents have been set. So I'm less concerned about it. But the issue isn't just simply whether you have standalone private enforcement in Hong Kong. It really goes to some of the other comments that have been made. You have to have more than just that. You're going to have some form of collective action if you're going to give the ordinance its full effect. And that also means you're going to have some form of funding. I know contingent fees are probably never going to happen in Hong Kong, but you're going to have to do something about that. Arbitration offers a good alternative for sophisticated companies, but it's never going to be able to really address the issue of the mass consumer harm, what I call mass volume, but small quantity harm cases, like the decorators cases that we had here, where, hundreds, thousands of people were victimized, but all in a very small amount. Nobody's going to have the incentive to bring that case to themselves.
Thank you, Brent. Well, the good news is we do have litigation funding for arbitrations. So we now turn to look at arbitration in resolving competition disputes. Now, once upon a time, the use of arbitration to resolve competition disputes has always been met with skepticism. And there are a couple of reasons for this, but the main reason being that, of course, competition law protects public interest, it protects consumer welfare, and it's thought that these very important issues should not be left to be tried by a private arbitrator. But then came the game changer. Several landmarks decision in the US and the EU flipped the script. The US Supreme Court led the way with a case called Mitsubishi Motors and Solar Chrysler Plymouth in 1995, and that was a classic tale involving a car dealer, car supplier, and a courtroom showdown over antitrust claims. Now, the Supreme Court decided that yes, antitrust claims are arbitrable, and there was no presumption against arbitration for statutory claims like the Sherman Act. Now, this ruling sparked a global trend with cases like the European Court of Justice's in Eco-Swiss Chinatime and Benetton in 1999, recognizing the arbitrability of competition disputes. The ECJ in that case particularly highlighted that ignoring competition laws could lead to an award being annulled on the grounds of violation of public policy. Now, fast forward to the English High Court's decision in Eurotunnel Plus and Velta in 2006. All is made clear. It confirmed that competition claims can be arbitrated provided they come within the scope of the arbitration clause as a matter of construction. So why are more parties choosing to arbitrate in competition disputes? Let's look at some benefits. First, there's party autonomy. Arbitration allows parties to select a neutral arbitrator, avoiding any actual or potential bias in the national court where the claimant or the respondent might reside, because nobody wants a referee who's a friend of the opposing team. Second, there's confidentiality. Unlike court proceedings, arbitrations are private and awards are generally not published. And so for businesses who doesn't want their dirty laundry aired, arbitration becomes a very good option. Third, there's also efficiency. Arbitrations are often much faster than traditional litigation. And there's also fourth, finality. Arbitral awards have very limited grounds for appeal, so that offers a sense of closure for all the parties involved. And finally, enforceability. Arbitral awards can be more easily enforced across different borders compared to court judgments, thanks to international treaties like the New York Convention. But of course, with great power comes great responsibility and even greater challenges. And I think this is especially true for a place like Hong Kong, where competition law is still finding its feet. I recently worked on a competition arbitration involving Japanese and US inductive manufacturers accused of price fixing, bid rigging, and a whole host of other competition law violations. The US purchaser claimed for damages for inflated prices, seeking treble damages under US law. And because the supply agreement was governed by Hong Kong law and contained an arbitration clause for disputes to be resolved at the HKIAC, the US court stayed the US proceedings in favor of arbitration in Hong Kong. And now this raised many intriguing questions, including are competition claims arbitrable in Hong Kong? Does the arbitration clause in question cover competition issues? How do we decide which competition laws to apply when the anti-competitive conduct spans multiple markets? Can an arbitral tribunal seated in Hong Kong impose treble damages? Is it a matter of procedure for the lex fori or the law applicable to the substance of the dispute? Now, unfortunately, this case settled, so we didn't get all the answers, but I think with the growing popularity of arbitration, I'm sure these answers will be resolved in Hong Kong very soon. Now, back to Kassie, you've had a lot of experience in competition-related arbitration. So can you tell us a bit about the types of cases you've been dealing with and some of your experiences?
Yeah, of course, Christina. Obviously, I can't go into any detail as regards particular arbitrations in which I've been involved, but I can share with you some of my thoughts on running competition and regulatory arguments in a number of commercial arbitrations which I've done. Sometimes successfully, sometimes not so successfully, but I have run those sorts of arguments either by way of defense or as a claim in commercial arbitrations involving agreements in industries as diverse as oil and gas and mobile phone technology. So as I've said, they can be an effective defense, competition arguments in contractual claims, but also form the basis for the substantive claims themselves. I'll focus, because that's where my experience has arisen, on EU competition law. As I've already mentioned earlier, EU competition law is comprised in two treaty provisions, Article 101 prohibiting competitive agreements and Article 102 prohibiting abuse of a dominant position. Importantly, if contract terms are found to infringe either Articles 101 or 102, they are void ab initio and unenforceable. And also a breach of Articles 101 and 102 can give rise to a claim for tortious damages. So EU competition law can be used as a shield, as a defence in a contractual claim, or as a sword by parties in arbitral proceedings. Predominantly, I've seen EU competition law issues used as a defence in contractual claims. So, for example, in both of the industries I've mentioned, in the supply of gas and in patent licensing of mobile phone technology, it's possible to argue that the supplier, for example, of the gas or of the mobile phone technology has a dominant undertaking or dominant position in the relevant market, so that Article 102 is engaged. And if that can be established, then a customer may be able to challenge or resist the enforcement of clauses in supply agreements, such as exclusive purchasing agreements, requirements, volume or take or pay requirements, which may be set at levels that foreclose the market to competing suppliers, and of course pricing clauses on the basis that the price charged under the contract is excessive or discriminatory. And as I've said, if such clauses can be successfully challenged by a defendant as being in breach of Article 102, they are null and void ab initio. Obviously, the consequences of that are a matter for the applicable national law of the contract, but such arguments can be used, for example, to resist a claim for non-payment. And I've seen those sorts of arguments run in arbitrations relatively successfully. So conversely, as I've said, a customer may be able to rely on such competition law arguments to give rise to a claim for damages or restitution, and thus use competition law as a sword. I've even been involved in cases where payments have already been made under a contract, but the customer has argued that the contract is in breach of Article 101 or 102, therefore it was void ab initio, and repayment of monies paid under the contract should be made by way of damages or restitution. Those are some of the types of competition-related arbitrations in which I've been involved. The key issues that have arisen in those sort of arbitrations? Well, the first key issue that has generally arisen is that of establishing jurisdiction. In order, of course, to rely upon EU competition law, as Catrina mentioned, you need to establish that it's engaged on the facts of the particular dispute. Now, that should be relatively simple when you're dealing with a contract between parties established in EU member states, involving the supply of goods or services across the EU. You have to establish that an agreement has an effect on trade between member states, so there has to be a cross-border element, but that shouldn't be difficult where the parties are established, for example, in different EU member states, or even in the same member state if there's a potential impact on trade between those states. It's probably unlikely, although not impossible, that such EU-focused contracts would be arbitrated in Hong Kong. However, even if one or potentially even both of the contracting parties are established outside the EU, as is more likely to be the case in a Hong Kong arbitration, EU competition law may still be applicable. In order to establish jurisdiction in such a case, it will be necessary to establish either that the contract has been implemented in the EU, for example, goods or services have been supplied into the EU under the contract, or the operation of the contract has direct, substantial, immediate effect in the EU. So this is called the qualified effects test. And if, for example, even in a case where the contract involves supply of components which are incorporated into finished products, which are then supplied into the EU, the European Court has held that jurisdiction may be established. I'm thinking here of the Court of Justice's 2017 judgment in Intel. In that case, the EU Commission had considered the legality of rebate schemes and naked restrictions, which it found Intel had employed in its customer contracts to exclude competition by Intel's rival AMD in the manufacture of a particular type of CPU microprocessor. Now, Intel argued that the Commission didn't have jurisdiction over its agreements, and you might have thought, given the facts, that that was a relatively good argument. Intel was a US-based company. It was manufacturing CPUs in Taiwan. The contracts that were being considered by the Commission were those that it had entered into with its customer Lenovo, a Chinese-based manufacturer of computers. And Intel disputed jurisdiction on the basis that the customer contracts were concluded in China. They involved non-EU companies, and the CPUs in question were sold outside the EU. So you would have thought, in that case, difficult to establish that they fell within the jurisdiction of competition law, European competition law. But the Court of Justice held that the Commission did have jurisdiction to apply EU law to the conduct in question on the basis of this qualified effects test. And that test involved asking whether the conduct at issue had an immediate and substantial effect in the EU. And the Commission held that it was enough that some computers with Intel CPUs were sold in the EU. That in itself was enough to satisfy the qualified effects test. So therefore, even in the case of contracts concluded outside the EU involving non-EU companies and products sold outside the EU competition law may still apply if it can be established that the anti-competitive conduct had effects in the EU. So once it's established European competition law is applicable, the second key issue is to establish the dispute is arbitrable. Well, Catrina's already addressed that point. It's now been held in the US Supreme Court and in the CJEU that competition law issues are arbitrable and they're matters of public policy for the purposes of the New York Convention. And may, in fact, even be the case that there is an obligation on an arbitrable tribunal to raise antitrust issues even if the parties haven't done so themselves. Commentators have indicated that such an argument is particularly strong if, for example, EU competition rules are part of the applicable law. They're part of the law of the seat of the arbitration, or, and this is probably more of most relevance to Hong Kong-based arbitrations, the arbitrable award is likely to have to be enforced in an EU member state. As an arbitral tribunal must ensure that an award is enforceable, it must also take into account the antitrust rules of all possible or likely places of enforcement. So it may be, again, that in a Hong Kong-based arbitration, that is a relevant issue. So in my experience, in both defending clients against competition claims and running competition claims in commercial arbitrations, I found that the substantive issues which arise are obviously not that different from the substantive issues that arise when you're running such claims in front of a court. However, what I have found is that you are often running such arguments in front of a non-expert tribunal. So it's important to develop the legal arguments on competition law from first principles. And of course, expert evidence, in particular economic evidence, will be important, particularly in any Article 102 case. And in arbitrations, just as in court proceedings, it's important to get an expert who can keep it simple and explain the concepts clearly and concisely. What I've also found, which is interesting for those of us who generally litigate in front of courts, is that there appears to be much more scope in front of arbitral tribunals to employ expert evidence on the applicable law. Although generally expert evidence wouldn't be adduced in normal court proceedings unless a court were being asked to apply foreign law, I've regularly encountered and have relied upon expert evidence as to the applicable law, specifically European competition law in arbitrations. And I found it appears to be expected in front of tribunals in certain seats that you get your professor of European competition law coming and giving evidence to the tribunal on what competition law says, the European competition law says, and how it should be applied. And obviously that will be useful if you're running unfamiliar European competition law arguments in front of, for example, a Hong Kong-based arbitration. So those are very briefly, some of the issues that I've come across in running European competition law arguments in the context of arbitrations.
Thank you, Kassie. Anneli, the use of ADR has recently been made mandatory, I understand, in the UK. Can you tell us whether it has been effective in resolving competition disputes?
Yes, so it's quite a recent change to the CPR rules introduced in September of this year, that the parties, we've always had the overriding objective where you have to consider ADR before you issue a claim, but in most cases it's sort of given lip service. But now there's an actual mandatory obligation. The judge also has to refer the parties to mediation or some other form of ADR at the initial stage of the litigation. So we haven't seen it feed through yet into ongoing claims, but there's been a couple of claims where I've used other forms of ADR quite effectively, particularly in B2B claims. So the kind of small claims, the David and Goliath claims that I'd call, where you've got the principles of the law are actually quite, like RPM, principles in the UK are quite well established now, but there really is a sort of battle over was there retail pricing, and how has it caused loss and how much loss has it caused, which are the real battlegrounds. And the great thing about mediation, of course, is it opens up the pie of solutions, particularly where there is a commercial relationship that is capable of ongoing, because other forms of settlement can come into the equation, and you can so you can divide up the piece to offer ongoing discounts or ongoing flexible creative ways of remedying the loss without necessarily being in pure monetary terms. Why it works effectively is on both sides. If you look at the balance between the parties, I've acted for a claimant in Bell Lingerie, which was an RPM case where the Japanese company Wacol had instituted, on my argument, instituted RPM in the UK, and the claimant was just a single trader. And she brought a standalone RPM case seeking damages, seeking an injunction to stop the RPM, seeking damages in lieu of the injunction because of the damage it had done to the growth of her business. And she was really gutsy because the costs of bringing that litigation were enormous. I mean, we obviously had creative finance and but even the economic costs alone were going to be 600,000, and that quickly dwarfed the value of the claim. And what we did was we went to the court and said, right, we've tried to engage in ADR. The defendant's not, you know, in our view, wasn't playing ball. Could we have a court supervised mediation so that the court sets down the directions and the timetable, the parties go away, but there is an architecture around it so that if it fails, if somebody's not engaging, you can come back to court. And we had to report back to the judge to say how the mediation was going. And that discipline then created a framework for the parties to engage properly. From the defence side, I've done another claim where it was GRS, it was a seller of mountain footwear, where again, there was an alleged RPM. I was acting on the defence side that time. Well, as a defendant, you can be sucked into this litigation with a very poorly pleaded case against you, allegations that you just do not simply recognise that have been concocted, and the claim, once you're into the litigation process, it's very hard to get out of it. And suddenly you've got these wide-ranging requests for disclosure that are inordinately expensive. And there's a momentum and a pace that whatever, even if there's a minute amount of loss, you're going to end up paying all of the litigation costs under the adverse cost rule. So in that case, actually, the defendant, we proposed that we use some form of mediation, and we set up a procedure with the judge's help to create a situation where the parties put in position papers, it was called, of what their case was and what the quantum was. And then we got the experts involved. They agreed a methodology together before they went to give simplified versions of an expert report. And then we got together for what was basically a conciliation process. And again, there was the backup that if the parties didn't engage, you'd have to come back to court and you'd have to fight the whole of the litigation. And because of those sort of incentives and cost consequences, it's a good way of corralling the parties, and you can get a creative solution at the end.
So did it work in the end?
In both cases, it worked.
Ah, fantastic.
I mean, what was annoying is it sort of deprived the jurisprudence that we needed on damages for RPM and damages in lieu of an injunction going forwards. But it was a very satisfactory result, I think, for both sides, actually, and was a fair result.
Yeah. So before we wrap up this segment, I want to turn to the question of how we can ensure Hong Kong keeps pace with the international developments for competition arbitration. Now, arbitrating international competition claims in Hong Kong is, of course, not a problem, as long as the ultimate enforcement location recognizes the arbitrability of competition disputes. However, where the competition claim involves breaches of Hong Kong competition laws, or the enforcement occurs in Hong Kong, then, as Kassie mentioned, the concept of arbitrability becomes critical, because similar to the New York Convention, under the arbitration ordinance, if the subject matter of the dispute cannot be settled by arbitration under Hong Kong law, then the court may refuse to enforce the award in Hong Kong. Now, what's the state of play currently in Hong Kong? Follow-on actions are allowed, but as Jindrich mentioned, we're still waiting for the first one to make headlines. It's almost a little bit like waiting for the next season of your Netflix shows. It's all anticipation, but no new episodes. Now, these actions could be very attractive to third-party funders because liability is typically established and only damages need quantification. We've also mentioned that, interestingly, breaches of Hong Kong competition laws can be raised as a defense to contractual claims in Hong Kong. Unfortunately, the one and only one that attempted this in Hong Kong didn't take home any prizes. Currently, we've seen that standalone private actions for competition contraventions are off the table in Hong Kong, specifically sections 108 and 109 of the competition ordinance state that no one can bring proceedings based on a contravention of a conduct rule in Hong Kong. So this means Hong Kong competition law issues arising in arbitration are more likely to come as a shield rather than a sword under the current state of play. But I think despite these challenges, there is a glimmer of hope. Since the prohibitions in sections 108 and 109 of the competition ordinance only apply to the commencement of proceedings in any court in Hong Kong, there is at least some scope to argue that the prohibitions do not apply to arbitration proceedings in Hong Kong, because of course arbitration is not a court. Now, but what it remains unclear is how this aligns with section 142 of the competition ordinance, which gives the competition tribunal jurisdiction. Note, it does not say exclusive jurisdiction to determine private actions in respect of contraventions of competition rules. So what's the takeaway? I think to align Hong Kong with international trends, we have to embrace arbitration for competition disputes, but we need a clear legal framework to support this. So to strengthen Hong Kong as a global arbitration hub, I think we need at least two things so that people know exactly where they stand. First, we need provisions similar to those that apply to labor disputes under section 20, so paragraph 2 of the arbitration ordinance, to expressly allow matters falling within the jurisdiction of the competition tribunal to go to arbitration. And secondly, we also need clear statements that sections 108 and 109 of the competition ordinance do not apply to arbitration proceedings. So that we can allow standalone private actions to go to arbitration, or better yet, we can remove the prohibition to standalone private actions altogether in both arbitration and proceedings before the competition tribunal. Now, on that note, we're going to turn to Mike, who will give us a brief overview on sanctions, FDI, and export controls. But as we're running slightly out of time, I would ask Mike to...
I'll keep my remarks brief. And I just say by way of background, I'm a national security financial crime lawyer, but I will try and keep the trends of arbitration going and talk a little bit about how sanctions have played out in the arbitration space. So following Russia's invasion of Ukraine in 2022, many countries throughout the world implemented a whole suite of sanctions and export controls directed at Russia. Unsurprisingly, these sanctions have created all sorts of compliance headaches for non-Russian companies, dealing with sanctioned parties, dealing with trade sanctions that potentially prohibit them from continuing to do business in Russia, and of course, enforcement actions brought by government authorities all over the world related to the breaches of these sanctions and export controls. All of this was utterly predictable when the sanctions first started coming in 2022, and it's been completely unsurprising to people like me who are in the national security and financial crime space. What has been slightly more surprising to me, and I'd be very interested in my colleagues' take on this, who do a lot more arbitration than I do, has been that these sanctions have created a lot of issues in the arbitration context. First, the nature of these sanctions and export controls has created a number of commercial disputes between non-Russian companies and Russian companies. We see cases where non-Russian companies are prohibited from performing their duties under an agreement because of new sanctions or export controls that are put into place. We also are seeing non-Russian companies voluntarily choosing to leave Russia when they're not legally required to because of commercial considerations and reputational considerations. When they do that, they often breach contracts. And finally, the Russian government has been active in a number of ways, and one of the ways in which it's been active has been nationalizing assets of non-Russian companies that had operations in Russia from before 2022. So all of these scenarios and many others like it have created commercial disputes and therefore have led to arbitration. In the arbitration context, Couple issues that have popped up repeatedly from where I sit is that termination provisions in commercial agreements are a good deal. If a commercial contract has in place a termination provision that allows a non-Russian company to stop performing or to terminate an agreement because of legal changes, then they tend to be in very good footing. By contrast, if a commercial contract doesn't contain those provisions, they can find themselves in a very uncomfortable situation where they're legally prohibited from performing under an agreement, but they're contractually required to do so. So that can be a really tough spot for those companies. Other important provisions in agreements relate to the arbitration seat and the choice of law, especially for non-Russian companies that are looking to initiate arbitration proceedings. If it turns out the contract says that it's going to be governed by US law and the arbitration is going to be in New York, that party is going to be in a much better position than if the contract is governed by Russian law and then the arbitration is going to take place in Moscow. Now, when the parties have flexibility to choose the seat, I think we're seeing a tendency for them to look to venues that are relatively neutral when it comes to sanctions and have a long history of arbitration. And for those reasons, it's not surprising at all that a lot of Russia-related arbitration is taking place in Hong Kong, and I think we'll continue to see that happen. Another issue that has come up repeatedly relates to licensing. So the way that most of these sanctions regimes work, there are general prohibitions in the sanctions, and then government authorities have the ability to issue licenses that authorize parties to undertake activities that would otherwise be prohibited under the sanctions. These licenses come in a general form, so they're generally applicable to everyone. You don't need to do anything, you can just rely on it. Other licenses are specific, where parties have to reach out to the government and seek specific authorization to do what they want to do. Licensing issues pop up all the time in arbitration, especially when one of the parties in the arbitration is targeted by sanctions. Interestingly, in Europe, both the UK and the EU have also imposed legal advisory service restrictions. So sometimes counsel involved in litigation or arbitration actually need to get a license from a government authority to be able to represent their party before either an arbitral body or a court. Other point I would say, which is not a surprise to those of us who are in the sanctions bar, but I think sometimes is a surprise to arbitrators and litigators, is that getting these licenses can be very time consuming. We're talking months or years, not days or weeks, and that can be a very unpleasant surprise if you don't know that it's coming. Last issue that we get, which relates to enforcement. And I think you need to have some strategic thinking when you're going into an arbitration about what enforcement is going to look like. If you're a non-Russian party, you're bringing an arbitration, you think you're going to win an award. If you're not sure that the Russian party is going to pay and your plan is to try and enforce your award in Russia through Russian courts, that's probably not a great plan of action. So you might want to give that a second thought before you go forward. In terms of recommendations, and I hit on this already, really important to look at your contracts, especially if you're a company or you're representing clients that are engaged in international business in higher risk jurisdictions. Russia obviously is a higher risk jurisdiction, but at this moment in time, I think China is too, in light of all the new sanctions and export controls that we're seeing coming out of the United States relating to China. Make sure the termination provisions work, make sure the arbitration provisions are tight, and that the choice of law reflects what you want it to reflect. And the last point that I'll close on might be a tad self-serving, but I would just say, if you're a commercial lawyer and you're negotiating a contract, if you're an arbitration lawyer looking to initiate arbitration, bring in a sanction specialist. It really is, it's a slightly different skill set, and it tends to be a lot easier for us to help with these sorts of issues on the front end than on the back end. And given the way that these sanctions regimes work, both clients and law firms can inadvertently walk into breaches, even in the context of arbitrations and litigations. So don't be afraid to seek specialist help.
We definitely need specialists. And can I now invite Louise Wong to give some closing remarks?
Thanks so much, Kat, and thank you so much to all of you. It's been like such an amazing privilege to listen to all of you this evening, from the UK and remotely from the UK, and in particular from Brent and Jindrich, who have had so much to do with the Hong Kong Competition Commission and the Hong Kong competition regime. And a special thanks to Kat, who is, as mentioned before, driving force for for a lot of competition discussion in Hong Kong. And in particular, HKIC, representing HKIC this evening, it's great to have this forum. It's an amazing gathering of international experts on this topic, which doesn't often get discussed in Hong Kong. It's been amazing to hear about the different regimes and the sort of the history of competition laws and how it's developed in the US, Europe, and the UK. We're really interested here in Hong Kong, particularly that we've just had our not just had, but now that third-party funding is allowed in arbitrations in Hong Kong, though we still think we've got a long way to come, and a lot we have not seen the full impact of the third-party funding regime yet. From Kat's example, we haven't quite heard about the nature of competition issues being heard in arbitration proceedings in Hong Kong. Again, there's a lot to be discussed and a lot to be decided. But just turning to the landscape of HKIC in Hong Kong, we've had a really record-breaking year at HKIC. We had 281 new arbitration cases commenced in 2023, with a record total amount in dispute of $12.5 billion in 2023. And in 2024 so far, although it is now November, we've already exceeded our caseload from last year several months ago, and arbitration in Hong Kong's just been growing. Kat mentioned some of the reasons why arbitration has advantages generally. But just talking about Hong Kong and HKIAC specifically, we here have the unique benefit of the Hong Kong PRC interim measures arrangement, which provides parties in Hong Kong seated arbitrations with access to interim relief from the Chinese courts, including for the preservation of assets. And this has been a really big thing for HKIAC and the growth of our arbitration cases. Since the arrangement came into effect in 2019, HKIC has processed 144 applications under the arrangement, and 39 of them have been this year. So the frequency of such applications has just been growing and exploding as well. In 2024, HKIC also released updated administered arbitration rules. And we undertook a thorough review of the 2018 rules, which were working very well. And the 2024 rules are actually relatively minor amendments on the 2018 rules to improve cost and time efficiency of HKIC arbitrations, and also with slightly wider powers to improve the integrity and efficiency of the arbitration process. We also introduced some new provisions to codify what was existing practices in relation to diversity and information security and environmental impact. So we've actually already seen 100 cases opened under the new rules since they came into effect on the 1st of June this year. And we've had some very positive feedback about how the new rules are working. I don't know whether many of you have heard, but HKIC is opening a new office in Beijing this year, or hopefully this year, hopefully to be announced this year. We formally announced the opening of it, but we don't have a date yet. But we are expecting it to be before the end of 2024. And HKIC is celebrating its 40th anniversary next year, with the 10th anniversary of the Shanghai office as well. So the arbitration scene in Hong Kong is going really well, very strong. And as the Hong Kong competition ordinance also comes into the 10th year this year, maybe we will be seeing the reforms advocated by Catrina. But thank you very much for this excellent discussion. It's been a real pleasure to listen to you all. Thank you very much for you online as well.
Thank you. I just wanted to thank Kassie and Zoltán, particularly for joining us remotely, and also for Anneli taking precious time off trial prep to come here to speak to all of you. So thank you very much.